Heyo! It is Monday. It is Monday, right? I have to check. It was a long day yesterday of streaming. Yes, it is Monday today. Monday the 17th. I have a full month until my yearly paid vacation. Oh, it will be good. Oh, it will be good. Hello, people. Oh, morning from Arizona. Good to know. Good to know. Robil, loading information. Gigi, everybody say hi to Gigi. She is my super mod. Hempland, Wolfram, Neo Dark Matter. It's me, Josie is already here. Glad you made it. And a bunch of other people. And this is also streamed on Rumble. And I have a few people over there too. Hi. Hey, Teresa, how are you doing? Well, we are on day 6. And according to the final minutes of Thursday's stream trial date, the state will rest after they have done their redirect with this witness. And yeah, I'm not surprised, but I will ask you instead. I will put up a poll. You of else guilt. Spell it right, Nick. The question mark. And yeah, that's a yes or no question. Well, let's settle that. Yes, Christine, we are live right now. We are waiting for the state, for the court to open. And on Thursday, the judge said that everybody should be back in court at 10:15 Arizona time. And that is in about 40 minutes. But you never know. They have surprised us before by starting early if everybody is there, because the court works on their time, not my time. You are here, no need to wait. Yeah. Yeah. I'm not David. I can't call the court and demand things. Yeah. Let's see here. I will just check. Yeah, it has. They haven't even put up their stream yet. Sorry. Oh, do I have a Vices raid? Vices Viking raid. I thought he went off air a bit ago, but glad you're here. Glad you're here. I hope you are all here to watch what is possibly the last day of trial. But first, these housekeeping stuff. And as always, like, subscribe. Yeah, channel needs to grow. And if you find that, this guy is good, you can choose to become a member. It's $3 a month, and that is what keeps this channel floating. And I don't mind super chats, but if you're thinking of large sums, please go to Zachariah Anderson's Defense Fund. And if it's certain someone is thinking about large sums, I have an early morning workday tomorrow, so please save it until the 28th. And so yeah, and if you're on Rumble, I have no idea how it works. Give me monies or something, I don't know. And the reason why I ask you to maybe wait until the 28th is this. Friday the 28th is my Chatfaced for Charity fundraising stream for Zachariah Anderson. And the members have voted, and $150 to Zachariah's defense fund, $50 to me. That could be via PayPal or Super Chat or membership if you choose. I'm not picky. And then I will take a full shot of whiskey, and a full shot is 2 ounces. Just so you know. And follow me on Twitter. I think I have a Facebook page as well, and stuff like that. Yeah. So housekeeping, book Friday the 28th. There will be shenanigans. There will be guests. I hope that Solomon can come on, and everything in between. And we will just have a jolly good time watching me get chat-faced. Yeah, okay, that was housekeeping. Let's see here. Now, I want to play for you the absolute last thing that happened on Friday stream, so we all can hear it, what was said. Oh, wrong page. There.
So on Monday, we're going to start with redirect of the officer.
You can't be serious. Buffering.
And then the state's going to rest.
That's correct. That's
I have excellent internet. Wow, thank you, Janks, a lot for gifting 10 memberships. Hempland TX. Hempland. Oh, now I get it. Thank you so much. And the gift was loading information. Mads, Soko SLP, Kitty, Jackie Kennedy, Deanna, Brandon O'Neill, Smo på Vienna, TMF, Victoria. Thank you so much, Hempland TX. I'm guessing that is Texas. That is very, very sweet of you. Thank you so much. I'm very, very appreciative of this. And where was it? Yeah, let's see if we can play this without interruptions.
correct, Judge.
Okay, so counsel, I'm going to ask you to be here at 10. At 10 on Monday. Cancel that. You can just be here at 10:15. So we'll finish up with the officer, and then we'll figure out after the Rule 20 is argued, we'll figure out what's going to come next. I assume if you're planning on calling any witnesses other than your client, you'll have them here on Monday morning.
I guess the other question is if, I don't know how likely that is, but if the defendant chooses not to testify.
I don't know how likely that is. You all heard that? The second part of that. Let's go back. Don't buffer, you bastard. How do you find me on Rumble? I think Gigi put out a link earlier, but I will. Here it is. Link to my Rumble. Yeah. Let's go back and hear this again, so everybody hears it.
Other than your client, you'll have them here on Monday morning.
I guess the other question is if, I don't know how likely that is, but if the defendant chooses not to testify.
It's unlikely that the defendant chooses not to testify. So that would mean if he didn't misspoke, that means that Michael will take the stand. Yeah, that's a bad idea. That's a really, really, really bad idea. But that at least it indicates that during this stream, first they will do a redirect the prosecution of their witness. Then the state will rest. And then, if the defense attorney didn't misspoke, Michael Turney will take the stand. From an entertainment point of view, yay! From a legal point of view, oh, he has the right to. Seeing how this case, this trial developed, oh no. Oh no. Yeah, that's bad. You who are watching at Rumble, please write something in the live chat. So other people that joins on Rumble knows that there is some activity. Would you please? Thank you. Oh, yeah. So that is where we are. The trial will commence today. The state will close. Then possibly Michael Turney will take the stand unless the defense managed to talk him out of it during the weekend. And then we can hear from him. Only one R in Starow. I think rumble.com/c/Nick Starow trial watch, one word. Yeah. Okay. Yeah. MG Law is here. If it's the defendant's choice and not his attorney's choice, they can recommend him not to testify, but if he wants to, then he will. Exactly. But they can recommend him throughout the weekend, the possibilities of him talking himself into a life sentence. But if Michael Turney wants, it is his full right to testify and open every door possible. But we don't know. We don't know how he will testify. But yeah, I agree with David's. He should not. I believe that. Here's the deal. There is nothing here that points to beyond reasonable doubt in this trial, and I doubt they will find anything on redirect. I was thinking that we could possibly go back and listen while we wait for the trial to start again and listen to the state's opening statement again. And you tell me if you think they actually actually went through with what they promised. Why are you buffering? I don't get it. Do I have some kind of app going? I only have Enhancer for YouTube. That's all I have. Maybe I should just remove it and see if it helps. Maybe it's that what's going on. Let's just remove it and see what happens. Okay. All right. Where is it? Where is it? Hi, Nicola. Good to see you. Yeah, but let's see here.
Is Sarah?
No. Da, da, da. Jesus Christ. This is so damn unnerving.
Few minutes are
Why are you buffering?
State may proceed with its opening statement. Counsel, whenever you are ready. It looks like your computer may have gone to sleep.
Did I break something? Is there something wrong with my sound? You in the chat, you tell me, is there something wrong with my sound? Can you hear me at all? Woohoo! I see that Hempland is present on Rumble. Okay, I'm fine. Okay. Sound is low on court. Yeah, I know. But it keeps buffering. That's it. I can... What's going on? Oh, Jesus Christ. There. Dun, dun, dun. There. Add to Chrome. Dun, dun, dun. I'm adding enhancer for YouTube again. There, there, there. All right. This is so fun. We need a representative from Norway and Finland. I can see if Baker is... Baker is streaming. But let's listen here. You tell me if you think the prosecution delivered anything from...
Remember the other day? Well, welcome back. Thank you for your kind attention. The other day when we were here, I think I told you that sometimes I tend to be soft-spoken. So I'm going to speak into this microphone. Feel free to raise your hand at any time if you can't hear me. Same for anyone. If you didn't hear one of us ask a question, feel free to let us know. Just a couple of preliminary matters. A couple of them were covered by Judge Myers. First of all, this opening statement is meant, I will attempt to give you an outline of what I expect the state's evidence to be. I won't discuss every witness. I won't discuss in this opening statement everything that I think they will say. The purpose is just to give you some expectation of what you will hear. In just a minute or two, I'm going to begin talking to you about Alissa Turney. Try to give you some sense of who she was, what her life was like, who her family was, those kinds of things.
You have to be freaking kidding me.
Another thing I want to let you know is that occasionally you may hear a party request, the state request to put a witness on out of order. In other words, they may have testimony about an issue that actually somebody else has already talked about. And you might be wonder, well, why weren't they called first? Well, witnesses have lives just like you do. So we attempt to make life a little easier for them to get here, not interfere with their work schedules as best we can, those kinds of things.
Yeah, but instead you chose to interrupt these jurors' time with this trial.
Third, as you will hear in just a moment, there will be people testifying in this case about events that happened in the late 1990s, early 2000 and 2001. So for some of those folks, we're asking for their memory of events that occurred.
You have to be freaking kidding me. You absolute. Let's see here. I am going to do it like this. I'm going to close that down. I am going to restart there. I am going to pull that up. I'm share screen again, and I hope it will work.
20 to 25 years. I'm telling you this because what may happen with an individual witness, they may not recall something that they said 20 years ago. So occasionally you will may see that witness presented with a copy of a police report documenting an interview they did those 20-something years ago. It may refresh their memory, it may not, but that's a process that you will see take place. I expect in this trial as it does in many other trials. All right. State of Arizona versus the defendant, Michael Turney.
And he put his hearing aid on.
You'll discover throughout this trial that I'm not the world's greatest at electronics. So let me see if I can.
No, not 1.25. You have to be freaking kidding me. And it is buffered.
I may just have to do it by hand. This was Alissa Turney. Alissa Turney has not been seen alive since May 17th of 2001. The evidence will establish that despite efforts to locate her in all these years, her body has never been found. Her stepfather was the defendant. You will hear testimony about her family. There were her younger sister. His name is Sarah. Sarah will be testifying in this case. She had brothers, James, John, Rhett, and Michael. Some of those brothers were stepbrothers, if you will. John and Alissa had the same mother. Their mother married the defendant. The defendant had sons, Rhett, James, and Michael. So these families joined together. They lived in various locations, but at the time that Alissa was murdered, they were living at 17217 North 34th Street here in Phoenix, Arizona, Maricopa County. Alissa was, I believe the witnesses you will hear from are many of her friends, her family members, including her brothers and her sister. I expect that the testimony will
Oh, I tried to. I'm now playing this. I am on Chrome. I'm streaming via Edge, and it seems to work a bit better. Is it no sound on this?
what you will learn, I expect for the testimony, is that the relation.
Is it still no sound? Deo, can you hear me? Darn it. Very low. Okay. Let's see if I can get. There, enhancer for.
Had with this defendant was oftentimes trouble. Oftentimes there were conflicts between the two of them. You will hear testimony about that. You will see some documents that give you a real sense of what this relationship, this troubled relationship was. Alissa will, as I said, she had many girlfriends. She had a boyfriend. She had a part-time job at Jack in the Box. She had a savings account. She knew how to drive, but she did not have a driver's license. And at the time of her disappearance, she did not own a car. Perhaps the best historian for Alissa will be her younger sister, Sarah.
Do you think so, chat? That Sarah was the biggest champion on the stand? I'm not so sure. I did not find her, especially as my brand new car chair is creaking. That's freaking annoying. Am I way louder than the court stream? Okay. Audio lowering. Better? Yeah. Especially as long as the trial, as the state's case moved forward. I believe that the prime witnesses became worse. Now, had the Sarah and the two friends of Alissa, as the day went ahead, and especially after hearing both cops during cross with almost exactly the same answers to the defense. Well, that was what Michael told us to do. Well, that was what Michael said. Always Michael, Michael, Michael. But remember what the prosecutor said earlier in his opening statement. Despite efforts to find Alissa, her body was never found. And I would argue the first 7 years, that was only because of Michael. Oh, really? I haven't listened to the podcast, but if by any chance the jury, because if state is done with the case today, this morning, Arizona time, then Michael might take the stand, and I don't know for how long, and then we might have the situation that this afternoon there will be closing statements, and then it will be given to the jury. Now, this should be a 5-minute decision. Coming back to why the F did you waste our times? Not guilty. And then it's been done with it. But you never know. And if they were to be taking longer, then we have a verdict watch tomorrow. And then we can play maybe Sarah's podcast, one of her episodes where she talks about what she believes her dad did. Let's go on.
Sarah was, and I hope Sarah doesn't, I believe, I can't remember if she was 12 or 13 years old at the time that Alissa disappeared. I think Sarah will describe to you maybe what many of you have observed.
Yeah.
A typical sister relationship. Not always the greatest. They had their issues, but they loved one another. I believe Sarah will tell you when she testifies that as she looks back on this relationship, it's clear to her that she did not appreciate the relationship as much as she does now, as it was taking place then.
Yeah, but that's not exactly how the testimonies went, where they tried to, almost best friends. But it crept forward during cross-examination that no, it may not have been that very good.
Alissa will be described to you as friendly, outgoing, made friends easily, tried hard to do well at school. Just a typical teenager. What you will discover through the testimony is that this defendant, for whatever his reasons were, attempted to basically control every part of her life, every day of
Really? That I don't think that is what came up during testimony in this trial. Did he record everything? Yes, everything. Not just her. Did she have freedom? She had a boyfriend. She could take boys home. Did he interfere? Yes. But did he attempt to control every aspect of her life? I don't think that was shown in this trial at all. Was he paranoid? Yes. OCD about the recordings? Yes. Did he try to control every part of her life? She had a job, school, friends, boyfriend. Hey, Sal.
her life. Whether she was at home, whether she was at school, whether she was at work. That control, certainly her younger sister Sarah, as her parent, you would expect for both of them to exercise parental control. This was, you will discover from the testimony, above the norm. And he treated them differently. Treated them differently, you will discover from the evidence. You will hear references that this defendant made about Alissa, derogatory comments that he made about her.
No, we are waiting for today's.
As having mental health issues, things like that. This case began May 17th. Well, obviously it began 8 years before this, but the investigation into her disappearance began on May 17th, 2001. I think, as I said a minute ago, she had just recently turned 17. This was the end of the very last day of her junior year in high school. I believe the evidence will be that since it was the last day, the last class day, that it was not going to be the typical hours. In other words, she would not have been, school would not have been over later in the day as it normally was. But she went to school. Sarah went to school. They went to different schools. Sarah was younger. Sometimes they walked, sometimes they rode. Sarah rode a bus. Sometimes the defendant would take them to school. It just depended. And speaking about the control that this defendant exercised over really everyone at some stage of their lives, of his children.
Is this better?
He recorded phone calls, incoming and outgoing phone calls from the house. At the time of Alissa's disappearance, there was a surveillance camera in the carport, and I'll show you a photograph of this house in just a moment. But let me just give you a little background. There was a surveillance camera in the carport.
We are waiting for today's court. It should be on quite soon.
Kitchen door entrance to the carport.
Do I really have I'm down at 40%. Do I really have that hot mic still?
And I'll show you some clips of a couple of those videos. That surveillance camera was focused on a couch, a sofa, in in that living room at the time. Sarah will tell you that there was sometimes the defendant would set up a camcorder in different parts of the house. You'll hear testimony that the defendant not only recorded phone calls, but sometimes recorded conversations with people with the tape recorder. The evidence you will hear is that on that May 17th, 2001, approximately, well, sometime before noon, shortly before noon, the defendant came to Alyssa's school and picked her up.
I have an enhancer on and sound on max on edge. So
Took her out early.
let's see if they have there.
You'll hear testimony from her boyfriend that she had at the time, Mr. Lackey, that Alissa stopped by and told him. I'm leaving my dad. Just picking me up. That's the last time that John Lackey ever saw Alissa.
I have enhancer on and everything.
You'll hear testimony that a young man that knew her was graduating, was a senior in high school, and was graduating later that day. He was expecting her to come to his graduation. She never showed up. She had, as I told you, a part-time job at Jack in the Box. She never showed up again. All we know about what happened the rest of that day as it relates to Alyssa's disappearance is what Sarah will tell you that she observed and what the defendant has told people over the years. You will not. So later that day, on May 17th, the defendant called the police department, filed what was referred to as a runaway report, claiming that she had run away from home. He was supposed to pick up Sarah from school. Sarah's went to since it was her last day of school as well, they had an outing that they went to. He was supposed to pick her up at school. He did not appear. She went to a friend's house, which was not unusual, she will tell you, for her to walk to that friend's house. It wasn't very far away from the school. The defendant had picked her up there on other occasions, and that's what happened this time. He did not pick her up at school. He picked her up at her friend's house. The evidence will not tell you exactly what time this was, but it was late in the afternoon of May 7th.
Yeah, we are waiting for trial
Sarah
to
will
start
tell you
today.
that the defendant told her, I can't get hold of Alissa.
Yay! People are getting it.
Alissa had a cell phone. She's not answering. They got to the house. Sarah will tell you that she went into Alyssa's bedroom. Alissa was not there. There was, Sarah will tell you that she found a handwritten note that, and there's no dispute that it's in Alyssa's handwriting. There will be no evidence telling you when it was written, under what circumstances it was written. But the note said that she was going to California, that she had taken $300, that she was going to California because that's what her father and Sarah wanted her to do. Sarah will tell you that Alissa normally carried a backpack. That was not there. But what Sarah will also tell you is that on the floor of that bedroom, the contents, well, what appeared to be had been the contents of that backpack, school materials, books, etc., were dumped on the floor. She didn't observe, Sarah did not observe like closet cleaned out, like somebody might pack a suitcase and take their clothes with them. Her makeup was still there. Her cell phone was still there. There was a necklace still there that you will discover had been a gift from Mr. Lackman. You'll hear evidence that the defendant called various people to try to find out where Alissa was. When he called the police, he said he told the police on the phone that he discovered her missing around 5 o'clock in the afternoon. Unfortunately, you will discover the Phoenix Police Department receives.
Let me know if it's good quality mugs and stuff like that once you receive it. I know it's print on demand, and it is via Teespring, and they have been around for a while and stuff. So, but just in case, check if the quality is up to good. Check if it's good quality. I don't want to send my chat.
Hundreds, sometimes thousands of these types of runaway reports. So they did not go to the house to investigate. They did not go to the house to interview Sarah or the defendant. Unfortunately, you will discover they took him at his word that she had run away. He later advised the Phoenix Police Department that he received a phone call from California. And depending on who he talked to, he either knew it was Alissa, thought it was Alissa, presumed it was Alissa.
That didn't really.
He yelled at him. But there's no recording of that phone call. Over the next few years, again, the Phoenix Police Department did not really investigate this.
What the fuck is them? See what he forgot to say? There's no recording of it. No? But there's phone records of it that he supplied to you. And you still didn't do jack shit about it. I think he started on one of the first witnesses, but I don't remember which one.
Other than, if, for example, an unidentified body was discovered in Arizona or California or Texas, they did manage to get the DNA profile. They obtained dental records from.
This is interesting. This is really interesting because during cross-examination of the final witness, the defense attorney, Stumpy, tried to get into this, but wasn't allowed to. The different paths they could have gone, including not only people they chose to get dental records and DNA from, but there were others, and he wasn't allowed to ask about it. That's really interesting. But I do know that I have David on in chat and MG Law. It is from Let's see here if I can bring it up on this. See if it's works better now. Oh. Let's see here. There.
Anything for the
No, Your
record? Anything for the record from the defense?
Yes, Your Honor. Now, I find it troublesome that the rules here are not being followed. The witness here has testified that he did something or didn't do it because of a reason. This hearsay information has a clear exception under the rule. The rule is the effect on him. So the jury should be able to hear what information he learned before he decided to omit it and say that it didn't happen. This is a continual thing. It's the same thing with Heimer. It's the same thing with this witness. The detective has chosen a narrow path on how he's decided to investigate this case. By limiting these questions, you are not allowing us to let the jury know about this. This hearsay exception is there for a reason. It's there because it allows testimony like this to determine and let the jury know why someone did or didn't do something.
If you want to ask him that whether or not he investigated information that was provided to him in a letter or in a phone call or in an email, you can ask him whether he investigated that information. As to what the specific claims were in the email or the phone call, that is hearsay. I hear your argument. I understand your argument. I disagree with everything that is said to him is fair game because it had something to do with his investigation. If your claim is that you are not asking for the content to be introduced for the truth of the matter asserted, then the content is irrelevant and the effect on his investigation is relevant, and you are free to ask him that. You and I disagree on this issue, and I've made my ruling and you've made your record.
Right.
Anything else you want to
Just further that I believe by limiting the defendant's right to a full trial, you are affecting his constitutional right to a fair trial. I believe that, and we will be making an offer of proof on Heimer as well as a directed verdict for a corpus delicti, and I will have that hopefully to the court tomorrow. If not, it'll be over this weekend.
Okay. So on Monday, we're going to start with redirect of the officer, and then the state's going to rest.
That's correct. That's correct.
Yeah, and now let's, because I do feel that this is unfair due to.
Unfortunately, you will discover they took him at his word that she had run away. He later advised the Phoenix Police Department that he received a phone call from California. And depending on who he talked to, he either knew it was Alissa, thought it was Alissa, presumed it was Alissa. But there's no recording of that phone call.
Okay.
Over the next few years,
The trial has started, so we can come back to this later, but it seems like we are live. Let's see here. And the sound from the stream from court is crackling. I'm hoping they will fix it. This is not from me, it is from, and of course it didn't start Yeah, they started late.
Deposits, one from 5/17/01, correct?
Yes,
And that was about $10 because she took out 200, correct?
dollars and some change, $10.80 something dollars, $10.80 some cents and change.
And there was another one for 5/22/01, correct?
Yeah, if we're going to go through them in detail, do you want to display them or show them to me?
If I wanted to do that, I will do that. I'm asking you questions about them. Do you remember that one?
I remember the statements, yes.
Now, we had talked about the fact that there was probably 11 or 12 checks that she may have gotten within that time period
This is from the 5th.
that Mr. Turney made on why that was recorded.
Yes.
And what was that?
Mr. Turney portrayed Mr. Lackman as violent and a danger to Alissa, somebody that Alissa was afraid of and was actively trying to end the relationship with. Mr. Turney stated he had kept that video to confront Alissa, to discuss.
No, let's go back here.
If we're going to go through them in detail, do you want to display them or show them to me?
If I wanted to do that, I will do that. I'm asking you questions about them. Do you remember that one?
I remember the statements, yes.
Now, we had talked about the fact that there was probably 11 or 12 checks that she may have gotten within that time period, correct? From
Yes.
starting in December to working till May.
Yes, every 2 weeks she is paid.
And I asked you specifically.
I will just check if it is the same crackling on Edge.
Okay, then I got up.
It is. Okay, I was just checking.
If there was any other checks deposited in that time frame, correct?
Correct.
And you said no.
Not that I'm aware. The deposits I have not seen to be her full and complete check.
There was a deposit in about December of 2000, correct? From Alissa. There's I believe, a slip that comes up with that.
Yes, it has her signature on it and her stepfather's driver's license on it.
Yes.
That one? Yes.
So that was a deposit and some money withdrawn also, correct?
Yeah, as is typical, yes.
But when looking at those records, there is not 12 transactions similar to that, is there?
I don't believe so.
And I believe altogether there was only 5 deposits between October of 2000 and May 22nd of 2001.
Is there a question there?
There was only 5, correct?
That would appear correct, yes.
There is a bunch of other deposits we talked about in the amount of like $1 or $2 that periodically happen, correct?
Yeah, that would appear to be the interest accruing on the account adjusted into the account.
I
And there was about
think
30
this
of
is a
those.
retake on Thursday.
I honestly do not know the number of those smaller transactions.
Now, I want to ask you specifically about some phone records of the Turney home. We found there was some discussion with Detective Summershoe about phone records or phone bills, correct? And I believe when the questions were asked to Detective Summershoe, those 2 words were used interchangeably, correct?
Yes.
In the police world, do you have a different meaning for those 2 things?
Yes, I do. Yes, I do.
And what is a phone record in your reference to that? If you were to put phone record in your supplement, what would you mean?
A bill is something that we found at the scene. It's a document where you are being billed by the company to pay for your services. There's a small volume of information included on that to explain the charges you are expected to pay. When law enforcement subpoenas records or obtains records through search warrant, I'm expecting a much more complex, much more detailed.
And there it buffers again. Okay, so I have to go by Edge, even though the sound is worse or lower, because this does. Jesus Christ.
Smaller transactions.
Now, I want to ask you specifically about some phone records of the Turney home. We found there was some discussion with Detective Summershoe about phone records or phone bills, correct? I believe when the questions were asked to Detective Summershoe, those 2 words were used interchangeably, correct?
Yes.
In the police world,
I don't know. Yeah, I thought the cross was done on Thursday, I believe. I thought so. So I don't know why this is being shown on Law and Seaward, because this sounds exactly like the final questions he had for him on his cross. Or either that, or it can't be a continuation because he already asked these questions. Yeah, no, that's on Law and Seaward. It's their feed. Okay, when court is late, they play random crap. Okay. Ah. I will have this on in the
you have a different meaning.
Yes.
background instead. And we can continue when I see they are okay. What do you want to talk about? Oh, so yes, the trial is commencing. We will finally hear some bad redirect, and then we might hear from Michael Turney. So should we trial swipe? Yeah. Yeah, let's try to swipe. Yeah.
The hospital to what he was wearing as he walked out of the studio. He had on a different clothes.
Hi, Kim.
Yes.
We are waiting for
We also
Lawrence
know
Lewis to start playing the
that,
right correct day. So we are stream sniping Jeff
the
instead.
victim's DNA was on Mr. Henry's shirt, correct? Yes, sir.
He is enhancing
We also
his
know
audio, and I
that
am
Mr.
enhancing
Henry
his audio.
had GSR located on his hands.
2 parts GSR.
Now, when Melly surrendered on February of 19, I think it was.
Borland
February
had
13th,
gunshot residue on his hand?
For all practical purposes.
Must have
I
missed
think
that.
you marked case closed by arrest, right?
Yes, sir.
When did
I can't
Sergeant
see there.
Williams
Let's see if I have something.
from BSO get involved, if you know?
The exact date I do not know.
Would it was after you closed the case, correct?
Yes, sir.
Do you know who asked Sergeant Williams to get involved? And he's the one who supposedly did the trajectory analysis.
That actually transpired when the case was filed with the state attorney's office. So sometime late January 2019. And it's also been corroborated by the fact that when they turned over discovery to you, it said trajectory analysis pending. So that information was made available to you back then. We just had not started that portion.
Would it surprise you to learn that?
I checked what the watch on the court feed from our trial said 10:26. So apparently, I don't think it seems live. So let's get back to that. Jesus Christ, this is so unnerving. Share screen, share screen, share screen. Add to stream. Sound.
Now, I want to ask you about the video recording of John Lakeman and Alissa, correct? You're aware of that video. That video's been shown in this court, correct?
I'm aware of several copies of that video, yes.
Are you aware of any statements that Mr. Turney made on why that was reported?
Yes.
And what was that?
Mr. Turney portrayed Mr. Lackman as violent and a danger to Alissa, somebody that Alissa was afraid of and was actively trying to end the relationship with. Mr. Turney stated he had kept that video to confront Alissa, to discuss the violence.
Did he ever say why it was recorded? Did he ever, in an interview, ever say why it was recorded?
Why it was recorded?
Or how it was recorded?
The security at the home was a constant.
Well, in fact, did he not say in that same interview with the narrator where he's been asked about that recording, he said, well, I did not mean to. I went to bed and I turned on the tape like I always do for the cameras at night. And then I realized that Alissa still had her friend there. Okay, then I got up and told him, you need to go.
That is not Lackman. That's the Michael Stanley incident that he's referring to at that point.
Yep, that's the video of the Stanley inside the home, correct?
Yes, I'm sorry. I thought you were talking about John Lackman, where John Lackman and Alissa are involved in that alteration, and he leaves the home.
Yeah, and in that particular video between Lackman and Alissa, there is 2 tapes of that also, correct?
Yes,
And is there one that has more footage than just the one that you received?
it's possible that there's a little more footage on that. Yeah,
And actually, that was turned on mid-argument, correct? There's nothing prior showing the 2 of them in the house arguing.
I do not know when that was turned on.
But on the video that you saw, is there any argument inside the home between Mr. Lackman and Alissa?
No, Mr. Lackman stated that Michael Roy Turney stopped him as he entered the home and then told him that she's cheating on you. That's
I
what
apologize for the crackling, but
There's
I
nothing
can't do
happening
anything
with
about it.
Alissa and Lackman arguing.
Is there in that video where Mr. Turney and John Lackman are in the carport where that conversation supposedly took place?
I'm not sure.
You were present while Detective Summershoe testified last week, correct?
Yes,
And he was asked,
Yeah, and here they refer to last week. So yes, apparently I thought they were done with the cross-examination, but apparently not. Maybe something happened with the motion that he could restart the cross-examination. I have no idea.
has Phoenix PD ever received any information about Alissa being seen, heard, or found since May 17, 2001? And he answered no. Do you remember that?
that's correct.
Now, over the years, there has been information provided to PPD about Alissa, correct?
About Alissa? No, about possible sightings, possible leads, things like that, but none of them have materialized to the point that we can say Alissa survived May 17th.
I agree, but you agree that people called in and at least said that they had saw Alissa.
Oh, absolutely. After that ABC, that was 6 million people that viewed it that night. Detective Summershoe and I both spent the next couple of days.
That says 10:30, doesn't it? Let's see if I can get a better. No, that's the best quality. Or am I totally off the rails?
Taking incoming calls.
Some of them you investigated, others you did not, correct?
That's correct.
Now, as a detective, is it common to work with police officers from other cities? Sometimes if you need help,
Yes,
and sometimes they'll call you asking for help in a situation in Phoenix where you can go collect some evidence or do something, correct?
routinely. Yes, absolutely.
And you are aware that you can do the same thing with them, correct?
Certainly, we have on multiple occasions.
We talked a little bit about, during your investigation, you reviewed hours of videos, including surveillance videos, correct?
That is correct.
Now, we talked about the layout of the Turney home a little bit. Discussed where the cameras were from your vantage point of videos that you saw. One was outside in the carport.
out area. There was a bench set up and there's some tarps hanging down.
What about the front two windows of the?
What? No sound? How is this possible? What the action? Okay, I'm pressing play.
Is there any cameras pointed at?
You can't
those
hear.
windows?
You can't hear anything.
Based on your recollection, are one of those two front windows to Alyssa's room?
Yes.
Is there any video footage from a hallway where Alyssa and Sarah's bedroom?
Can you hear anything at all besides me?
No video footage showing the hallway.
Now, as part of your investigation, you reviewed the Starbucks,
Okay, let's go back a bit.
the one that you received.
It's possible that there's a little more footage on that. Yeah.
And actually, that was turned on mid-argument, correct? There's nothing prior showing the two of them in the house arguing.
I do not know when that was turned on.
On the video that you saw, is there any argument inside the home between Mr. Lackman and Alissa?
No, Mr. Lackman stated that Michael Turney stopped him as he entered the home and then told him that she's cheating on him. That's what provoked the argument. But there's nothing captured with Alissa and Lackman arguing.
Is there in that video where Mr. Turney and John Lackman are in the carport where that conversation supposedly took place?
I'm not sure.
You were present while Detective Summershoe testified last week, correct?
Yes.
And he was asked, has Phoenix PD ever received any information about Alissa being seen, heard, or found since May 17, 2001? And he answered no. You remember that?
That's correct.
Now, over the years, there has been information provided to PPD about Alissa, correct?
About Alissa? No, about possible sightings, possible leads, things like that, but none of them have materialized to the point that we can say Alissa survived May 7th.
I agree, but you agree that people called in and at least said that they had saw Alissa.
Oh, absolutely. After that ABC, that was 6 million people that viewed it that night. Detective Summershoe and I both spent the next couple of days taking incoming calls.
Some of them you investigated, others you did not, correct?
That's correct.
Now, as a detective, is it common to work with police officers from other cities? Sometimes, if you need help,
Yes.
and sometimes they'll call you asking for help in a situation in Phoenix where you can go collect some evidence or do something, correct?
Routinely, yes, absolutely.
And you are aware that you can do the same thing with them, correct?
Certainly, we have on multiple occasions.
We talked a little bit about, during your investigation, you reviewed hours of videos, including surveillance videos, correct?
That is correct.
Now, we talked about the layout of the Turney home a little bit. You discussed where the cameras were from your vantage point of videos that you saw. One was outside in the carport.
Yes, outside in the far corner of the carport. It was an unenclosed carport at the time. The house had been since remodeled. That camera was pointed towards the main door on the interior of the carport.
And one was inside, which faced the couch in the living room, correct?
Yes, elevated position and air conditioning vent, and then facing down to capture the living room, specifically at that couch.
Did you ever come across any surveillance videos that you reviewed which showed recordings from the other side of the house?
The exterior, the backyard, yes, I think we have some that are dated later, but I believe those to be the 17218 house.
I'm talking about in the house where Alissa ran away. Did you find any videos of the backyard or the side of the house?
There are videos of the backyard, and I don't remember the side of the house, but the backyard when they had a trampoline family videos.
Yes, that's someone recording on camcorder.
Yes,
Is there any video surveillance that looks like it's just showing that there's a still camera capturing that area?
there is some that show a workout area. There was a bench set up, and there's some tarps hanging down.
What about the front two windows of the house? Is there any cameras pointed at those windows?
No.
Based on your recollection, are one of those two front windows to Alyssa's room?
Yes.
Is there any video footage from a hallway where Alissa and Sarah's bedrooms were?
No, no video footage showing the hallway.
Now, as part of your investigation, you reviewed the Starbucks recorded conversation that Sarah recorded, correct?
Yes.
You heard the deathbed comment.
Yes.
You also heard the defendant say that if she came back, she would get the same answer, correct?
That's correct.
as she knows right now.
That's correct.
He also told her on several occasions that he couldn't confess to something he didn't do.
Yes.
Now, during the discussion in this case, and we went through a little bit of numerous letters Mr. Turney wrote and numerous recordings on the phone. And so I just kind of want to do a little bit of, I guess, time frame of when those occurred. So you can, if you remember, if you need me to refresh your recollection, I can bring you a copy of that. But
I'll do my best for you.
so first, I want to ask you about the phone call that was played, the one between Mike Sr. and Jr., where he is describing Alissa. He's at his end with her. He's worried about, calls her a bitch. Do you remember the call I'm talking about? Do you remember the call I'm talking about?
Yes.
Do you know when that call occurred?
On the 28th.
Of what?
I'm assuming it's April 28th, but I do not have any way to take that recording and establish it.
Now, he says the 28th.
Just for completeness, we've got a month and a date, but not a year.
Well, I'm getting to that, and I don't think we'll ever know the exact year, but I'm going to try to clear that up a little bit. There is some talk in that conversation about the 28th, and it's a bad time for him. Correct?
Bad day, yes.
Are you aware when Barbara died?
1993,
February 28th?
February 28th, 1993.
Yes. Other reference to that February 28th date in other conversations, correct?
To February 28th, yes, or the date of her death.
So in that conversation that he's having with his son, there's mention of this 28th, how it's a bad day and stuff like that, correct?
He gives specific reasons for being a bad day in the
Yes.
call.
Yes, he specifically says the 28th is a bad day. And then he goes on in that call. And if I'm to get that correct, I believe he's talking about him finding drugs on Alissa, correct?
The biggest part of the call was her refusing to bond back with the family and him feeling he needed to call cops to address a drug issue.
And specifically, he's referencing something of $750 to $1,000 fine. He'd have to turn her in, something he would never want to do to any of his kids.
Yes, going to lose the house.
Now, we had heard testimony from witnesses in this trial about Alissa having memory issues, correct? Do you remember?
We've heard from Mr. Turney.
We've also heard from Sarah. She said that in the interview with you, correct?
She stated it in her initial interview. Yes,
She told you in an interview that Alissa had memory issues, correct?
correct. She said that in her initial interview.
But she told you in an interview, correct?
Yes,
Michael has said that also in communications with detectives over the years, correct?
oh yes. Many times he's described her as having a mild form of retardation. Her frontal lobe.
Objection, non-responsive, strike answer.
Sustained, counsel, when you're asking about Michael, are you asking about the defendant?
Yes, Michael Sr.
Okay.
He also mentioned that in the letter on May 25th, 2001.
Yes,
And as part of your investigation, you came across communications that predate Alyssa's disappearance, correct?
yes,
And you reviewed documentations or communications where Michael Sr. has claimed these things before Alissa ever went missing, correct?
correct.
Him making claims that she has a memory issue isn't something that he brought up after she disappeared, correct?
No, correct. Yes,
Now, there are plenty of communications with Mr. Turney had with school officials predating her disappearance,
correct.
with his concern about her academically,
Correct.
discussions about his expired IEP, correct?
Correct.
And one of those such discussions was February 7th, 2001, correct?
Yes,
He also mentions drugs in the home in that February 7th communication, correct?
found marijuana under a couch. Yes,
And February 7th would be approximately 21 days before February 28th, 3 weeks.
say exactly.
This is I have I don't know why. This is how I have arranged my it shows last video and live now, so that's probably why it's showing two lives. It's the same feed, it's the same stream.
This IEP and subsequent memory issue is something that he brought up many times after she went disappearing, or she went missing, correct?
After she was reported missing. Yes,
And also predating back years, correct?
yes.
There are also discussions of Alissa going to live with John and Mike in 2000, correct?
In May of 2000, she did go to live with John.
Okay.
And there is the signed subsequent documents pertaining to this that we've discussed in this trial, correct?
Parental custodial agreement signed in May of 2000, correct?
One was signed May 19th, 2000.
Yes, I believe so. Was it? Okay, yes,
There's another document that is 5/27 of 2000. Is that correct?
that's correct.
And then there is the revocation of that contract on June 2nd, 2000, correct?
Yes.
Now, we talked a little bit about the phone bills that were recovered. There's also been mention of an AMA dump or an AMA. I don't, what does that mean to you?
That is the phone record provided from Quest.
But what does that AMA mean?
AMADUMP, I don't know what the acronym stands for. It's what their engineers put together to provide us the complete history of that particular device, that particular phone.
And that's what was done when he requested the records or attempted to sue them for the record from the 5/24. And I say he, Mr. Turney, the defendant in the case, 5/24/2001 call, correct?
That's correct.
Now, one of those phone bills from July documents what happened the previous month, correct? So if you get a bill that's dated July 17th,
I don't know. I'm looking into my channel content on, and it's only has one live stream up. So I'm not sure what's going on. I'll see if I can. I should only have one live up and then upcoming live streams. Let's see if I remove that section. Publish. Changes published. And my channel. Update. Nope, it still shows 2 with different amount of people watching. This is weird. And I only have one feed here on StreamYard. I don't know why. This must be something on YouTube. It's it's not me. It's the Law and Sea word feed.
that's not for July records. That's for the previous month, correct?
It's a post-event billing. So if they bill you on July, it's for the month of June. If they bill you in June, it's for the month of May.
And when we discuss those roaming charges with the calls from California, that would reference a July bill, but a June event, correct?
Correct.
Now, in regards to the AMA dump, it seems based on what you learned that those records were received July 3rd, 2001, correct?
I don't remember the exact date, but yes, the first week of July is when Mr. Turney received the records.
Would reviewing your police report help refresh your recollection?
You could simply read the date off of it, and I believe that. I simply don't remember the specific date.
Now, also as part of your investigation, did you review any records or notes from Detective Schoenfelder about doing anything with the information that Mr. Turney, Michael Sr. gave him in regards to that call from California?
No.
Do you know if Detective Murphy did anything about that communication when she came on the case in 2004?
Nothing was documented regarding that May 24th call.
No. Do you have your supplements in front of you?
I do not.
You may.
There is no crackling. Crackling is still there, so it must be something between law, the court and law and C words.
There was communication between Mr. Turney and someone where he referenced getting the documents on July 3rd, correct?
Yes,
And I think other times he had said that it had taken about 6 weeks to get those documents.
that's correct. And going from May 24th to July 3rd would seem to be 6 weeks.
About 6 weeks.
Yes.
So also as part of your investigation, you received or found a receipt from the Best Western in Moreno Valley, correct? And that receipt was for a trip between 7/5 and 7/7, correct?
July, that's correct.
2 days after receiving the phone dump, correct?
Yes, I believe that's when he and Sarah went.
Now, we've heard testimony about Lynette who lived in California, correct?
That's correct.
Do you know whereabouts that she lives?
I don't remember the exact address, Torrance,
Torrance? And is that's near that area within 50 miles?
about 70 miles out away from the location of the phone call.
Now, there's also been talk, and you learned through your investigation that Alissa had family that lived in Oregon, correct?
Yes,
You have documentation and letters that were sent to Columbia County Sheriff's Office from 7/9/2001, correct?
yes, those were prepared by Mr. Turney.
And he sent them to the Oregon Sheriff's Office and enclosed the missing person flyer, correct?
Correct.
And that was shortly getting back from California if he was there from the 7/5 to 7/7.
Would appear to be.
I'm looking at the law and Seawood feed, and it seems like the chat there are complaining about the exact same thing. So it is from law and Seawood, the crackling and everything is.
And on 7/10, there's a letter to Detective Sean Felder documenting the letter he sent to Oregon and included a copy of that letter, correct?
Yes,
And in that letter, he talks about a description of a man.
Mhm.
That man was Paul Abbott.
Sustained.
You reviewed the letter sent by Mr. Turney, correct?
yes, it was part of the original case.
And he's giving information about Alissa that he had found out.
He is showing information that, yes, that he's sharing with detectives.
And the general gist of that is that it might not be significant, but I'm just trying to pass on this information.
Correct.
And he specifically references that at this point, it's just a runaway,
Yes,
but it's my daughter, and I can't help but worry.
yes,
Then on 8/30/2001, he contacts Congressman John Shadegg.
John Shattuck, yes,
Shattuck?
through Bruce Raven.
And this letter, he's being very critical of the police investigation, correct?
Absolutely.
He's asking for help in Alyssa's runaway.
Yes,
So that's in August of end of August 2001.
2001. Yes,
Also, as part of your investigation, you reviewed recordings, correct? Of conversations that Mike had.
yes,
One of those such recordings was on September 25th, 2001 with Sergeant White from the Phoenix Police Department, correct?
Sergeant Bob White, he was the original missing person sergeant at the time she was reported as a missing person.
And he's being critical in that of how the case is being handled.
Yes, he specifically, I'm sorry, yes,
And he's specifically talking about how vulnerable she is on the street,
yes,
trying to invoke someone to investigate his daughter's case.
yes,
Recording, doesn't it?
yes,
He actually starts crying.
sobbing, yes,
I just want my daughter back.
just want her back.
And in another letter dated 12/20/2001, he contacts another sheriff's office, correct?
I don't remember which one that was.
Kings County Sheriff.
Kings County, Washington,
I believe Kings County is in California.
California.
Yeah, I can't do anything about the crackling, I'm afraid.
But in that letter again, he is giving them information, correct?
That's correct.
He sends them his NCMEC letter and a copy,
Yes.
sorry?
His Nick Mick letter,
and a copy of a missing persons flyer, correct?
that's correct.
Then in January 16th of 2002, he sends another letter to Nick Mick, correct? Correct. Then on February 22nd, 2002, he speaks with Sergeant Roberts again, correct?
Sergeant Roberts is the new supervisor, the one who replaced White.
And so he talks to him on February 2nd, 2002, and he's discussing Alissa, correct?
It's a her, but yes,
So I apologize.
that's right, Mary Roberts.
And then in May 28th, 2002, he writes a letter to the Department of Labor,
Written to the Department of Labor.
but this one is specifically discussing his daughter,
Yes,
complaining about the lack of action.
yes,
That is in May. That's about a year after she ran away, correct?
just shy of exactly a year.
Or just more? 528.
By 28, yes, 11 days passed.
Now, there's some other interactions between 2002 and 2003, but in March 2003, March 13th specifically, he contacts the DEA, correct?
Yes,
And then on 3/17/2003, he writes a letter to Sergeant Robertson outlining the things he has done and his suspicion of people he has contacted.
Sergeant Roberts?
Yes,
Yes.
Robertson. I believe it's Robertson.
Robertson, should be Sergeant Mary Roberts still.
You are correct. Detective Roberts, or Sergeant Roberts.
Sergeant Mary Roberts, yes.
Now, from May 2001 to March 17th, 2003, there's no reports or anything from Detective Schoenfelder outlining any follow-up on any information that he was given.
Correct.
No one had heard from Alissa in 2 years at that point almost?
Yes, she's turned 18 and they still have not altered their approach.
Hmm?
Co-workers?
No contact with her coworkers, no contact with Barry Goldwater.
That's
students,
the Law and
Barry
Seaward
Valley students,
stream.
No canvas of her neighborhood.
But the letters don't stop there, do they?
They do not.
He contacts Chairman Boerner, Boerhner, on June 17th, 2003, correct?
Yeah, that's Boehner, isn't it? Boehner.
I don't know. That's why I spelled it. I don't know. Is that, I mean, are you familiar who that is?
Yes.
And he contacted them, correct?
Yes.
And then in about the beginning of 2004, it looks like that's when Detective Murphy takes over, correct?
I believe so.
And between 2004 and 2006, there's communication between Detective Murphy and Mr. Michael Turney, correct?
Mr. Michael Roy Turney, also with John Turney.
There is some contact between them. He's giving them information. There's some of the things about dental records and all that happens between that time, correct?
Yes, before Detective Murphy, there was no way to identify or legitimately compare any unidentified human remains with that missing child. So Detective Murphy reached out to try and create that pedigree.
And then on December 4th, 2006, there's a call from Detective Murphy and Mike Turney discussing Alissa's case.
That's correct.
And then we get to January 1st, 2007. There are other calls reference Alissa's case with the Congressman Sean Shadegg or Shadegg?
On Shaddy.
Shadegg, correct?
Yes. And it's not with the congressman, it's
With
with
the aide.
his aide, Bruce Radin, who I interviewed.
And then on January 1st, 2007, there are other calls reference Alissa's case when he contacted Senator John Kyle's aide, correct?
Correct.
And he's asking them to help about his case,
Yes,
get word out about Alissa.
absolutely.
He also goes further and contacts Janet Napolitano's office too, correct?
I believe he did. I don't have any recordings of that. I think that was a letter.
And she was the governor at the time,
She was.
and he's discussing her case, trying to get action.
Yes,
Then in February of 2007, there's contact with the FBI in reference to Alissa's case, correct?
correct.
And then April 15th, 2008, contact with NCMEC again, correct?
Correct. Nick contact was fairly consistent.
But even as much as April of 2015, he's still complaining about the investigation.
I'm sorry, April of 2008 or 2015?
2008,
2008, yes.
still complaining about the investigation, complaining about what has not been done.
Correct.
And in 2007, there are more calls where the defendant,
Okay, it seems like Law and Seaward are putting the stream up and down. Hopefully they are trying to fix the sound. Yeah, I can't do anything about it. And yeah. See here.
18th, 2008, correct?
Yes, that was the in-person interview.
And that's where he gave you, when you, 2008. November 18th, 2008, correct?
Yes, that was the in-person interview.
And that's where he gave you, when you went to the house, I guess, and he gave you the recording of the argument between Lackman and Alissa.
Yes, let me correct my statement. The first contact I had with Starow was September 12th. At that time, I arranged to have that in-person meeting to go to their home to collect evidence, and that was the 18th.
And that's when you came to the home.
Yes,
And he gave you that recording. That's the one.
marked 5-6.
That was found in the house is the one that's marked 516.
Yes,
And would you agree, looking at those two tapes, that the one on that was given to you on September 18th looked like a fresher pen? You could read the writing more clearly, correct?
I had to go back and collect that tape at a different date. But yes, it was the one mentioned and the one offered that tape.
The one that was found in the house looks like it had faded a little bit. It was with whiteout on it. But
Definitely looked more used. Yes.
Thank you, Debbie Wee, for becoming a member. This, yeah. There's members only stuff on my channel. There is also a link to Discord. Hopefully it still works. If it doesn't,
Mr. Jackson, any redirect, Mr. Bailey?
okay, now we are coming to redirect. Let me know if the Discord link doesn't work. In that case, I will give you another one.
Just to begin, there was some question about dental records. You obtained Alyssa's dental records.
Not me specifically, but Detective Murphy did obtain her dental records. They're dated from 1997, so they're mixed dentition.
Okay, and I apologize, that was a poor question, but Phoenix Police Department had obtained your dental records.
Yes.
You
4-year-old dental records. A lot of stuff can happen in 4 years. She got them when she was 13. She disappeared when she was 17. They can't do shit with dental records. And I do believe it's been excluded from using in court. They can maybe exclude people. Maybe. We don't know. Because it's shit science. So if they actually excluded someone because of dental records, Jesus Christ.
noted that there's, you were asked about some reports. Was there national media attention that was provided to this case?
Absolutely.
And was that the ABC primetime video that we have seen?
No, it was before that. There was national media attention on the John Walsh show. She was carried in various articles that are nationally televised. Nick Mick did a fantastic work with this child. There were race cars that had Alyssa's face put on them to promote her investigation. The case was actively active.
Okay, they are putting the feed down again. So at least we know that Law and Seward is trying to fix it.
And some unrelated issue?
Absolutely unrelated.
You were asked about how there was not a lot of work done initially by Detective Schoenfelder. You remember that?
I do.
Again, if you have a call that came in today where a parent says, my 17-year-old ran away from home, what action would you take immediately on that?
I am absolutely not going to lock down the border between Arizona and California in that situation. You have a 17-year-old person who knows how far she is away from being an adult. My only obligation, or the only thing I'm going to do, is ensure that she's properly identified in ACIC and NCIC. There is no condition where you start looking for a 17-year-old kid who left a runaway note behind saying where she was going.
And if that same parent calls in a week later and says that they had heard from their child, what would that do to your urgency in investigating her?
Completely deflated.
Why? She's still a fucking minor. At 17, she's a minor. Jesus Christ. She just turned 17. She's still a minor. And even if there was a phone call, oh, she's in California. Well, now she's a runaway in freaking California. And all you have to say, officer, completely deflated. You.
Did you do excuse me, did Detective Schoenfeld, excuse me, did Detective Summershoe do a follow-up interview with John regarding domestic violence?
Yes, we had the initial interview with Lackman. Detective Summershoe performed that interview. We then talked to Sarah Turney, and she expressed having seen a potentially violent exchange between the two of them. So Detective Summershoe brought him back and conducted another recorded interview to specifically address that allegation. It is not true.
On the video of the fight between John and Alissa that we have seen a number of times, do you ever see, is there anything to indicate that John did anything physically violent to Alissa in that video?
No, I object to I object to it being called a fight video. The child's walking in to see his girlfriend. He's cut off by her father. The father says, she's cheating on you. She mentions that to Alissa. There's emotional exchange there, and the boy walks away. He gets into his car, and yeah, he peels out going down the street. He's relieving some stress, but there's no violence. There's no violence in that kid.
Oh! Did you catch that? Even though there's testimony that the boyfriend had made her cry, that the boyfriend had grabbed her violently, he just said there's no violence in that kid. That's bias. He is nowhere near objectively investigating this case. He is so determined to get Mr. Turney that he contradicts sister and friends' testimony. I hope they get a recross on that specific issue.
You were asked briefly about an individual named Paul Abbott. Was he investigated?
He was. I've had several conversations with Paul Abbott, and for the record, he was investigated by detectives before me. He was located by Detective Murphy.
You were asked, there was a comment about Alissa having sex with older men.
Sit straight, ass.
The only two incidences that you're aware of with Michael Stanley that we've seen in the video.
That's not sex. That is a sexual. It is what it is. It's making out. He's the only person that we've identified that's had any sort of contact with her other than John Lackman. And it's easy to look down your nose and cluck your tongue at her for acting out in that way. But for law enforcement, my interest is asking what's causing her to act out that way.
The second incident that you're aware of.
You're not the psychologist.
At, John Turney, her brother's house.
Yes, there's a rumor that she may have hooked up at a party at that apartment complex.
If I call up and ask you to make a subpoena for me to get records, does Phoenix PD have the ability to be able to get just subpoenas, send out subpoenas for individuals?
No, I have no subpoena ability. I have no search warrant ability. I do not have magical powers. What I do is prepare an affidavit. If I'm investigating a crime and I can articulate to a superior court judge that I believe probable cause that this crime has been established, a judge or the county attorney will issue a subpoena that I will serve upon somebody to obtain records. In the absence of the investigation of a crime, I do not have that ability.
This pisses me off majorly, and we are not 2 hours in yet. You know damn well, officer, that had you gone with anything, you had a boss who had heavy petting, making out, and here you are, and now we know why he was never charged, because you looked at it and said, boys will be boys. It's Michael. Jesus Christ. Officer, how many innocent people have you put to jail? Officer, How many leads have you ignored because you were so tunnel visioned in one possible suspect? How many people are dead because of you, officer?
Can you determine the location? Can you determine who was making a call from California?
No.
Can you?
I can't put somebody on that handset without a recording of a voice. I don't know who they're talking to.
So it could be anyone.
It could be anyone.
Were you able to determine if that call was a collect call?
No.
No, you weren't able to.
No, it was not a collect call.
And that was a call from a payphone?
Yes, that was a call from a payphone.
After this, Alissa disappeared on May 17, 2001. Is that approximately 5.5, 6 months before 9/11?
Yes.
Did 9/11 create additional requirements for financial transactions?
Yes, it did. It required that these institutions are much more responsive to law enforcement in those events that I have probable cause that a crime is committed.
And do financial transactions help you in locating individuals?
They do.
You were asked questions about the runaway note. Does the note ever state that it's a runaway note?
It is not a runaway note. It is a promissory note. It mentions an argument that happened sometime before. It does not conform to the events that happened on May 17th, 2001. It was kept from sometime before that.
I'll sustain the objection as to non-responsive. The response is stricken.
May I follow up on that to make the record clear, Your Honor?
You can ask any question you'd like. If there's an objection, I'll rule on it.
Thank you, Judge. Does the note say that it's a runaway note?
No.
She disappeared in May of 2001, and then so 9/11 is a few months later. So that's why they are going at it about that. What's going on? Okay.
And to be clear, when we were talking about subpoenas, you did get a search warrant for the defendant's house in 2008 when you took over the investigation.
I did. When I took over the investigation,
Because you didn't even try to apply for any other. That's why you only had a search warrant for Mr. Turney's place. That's it. That's the only reason. Jesus, this guy pisses me off.
I'll just leave it at, sorry, sir. Yes, what a yes. No additional questions.
Thank you, Mr. Bailey. Ladies and gentlemen, any members of the jury have any questions for this witness?
Okay, not allowed to recross. Jury questions.
There are none. Thank you, sir. You may step down.
No questions from the jury? Okay.
How would the state like to proceed?
At this time, Your Honor, the state rests.
All right. Ladies and gentlemen, I'm going to take up some legal issues with counsel. I'm going to guess that it's going to take about 20 minutes. If I am wrong and leave you waiting in the jury room longer, I'll apologize, but we'll bring you back in as soon as we can. So I'll send you on break for 20 minutes. I'll ask you to be back in the jury room at 11:30. Please remember the admonition. You can leave everything in the courtroom. The jury is now excused.
Now we will find.
Counsel, I need a 2-minute recess, so I'll be back on the bench in just a moment.
No, the state rested. Now it's the defense. And they alluded to that they might call Michael Turney to the stand. But now we will hear from the directed verdict. We will hear about some objections the defense have had. And the question, will Michael Turney testify? Yeah, 2-minute recess. Yeah. I doubt it. As this question has been brought up with the other with U.S. lawyers, with David and Jeff, and I've heard it from others that it is extremely rare to grant a directed verdict. Oh, yes, new poll.
State versus Turney. Let the record show the presence of counsel and the defendant. The jury is not present. Mr. Jackson. Ms. Hicks. I see your rule 20 and your motion to dismiss, or in the alternative, suppress statements for lack of corpus delicti as very closely tied together. So I'm happy to hear argument on either or both together.
Judge, pursuant to Rule 20, the court must enter a judgment of acquittal if there is not substantial evidence to support a conviction. The case law defines substantial evidence as that which reasonable persons could accept as sufficient to support a guilty verdict beyond a reasonable doubt. The defense is asking for this court to enter a judgment of acquittal based on three grounds. The first is that there's been a general failure to present substantial evidence to support a conviction. The second is that there's been a failure that the state can establish jurisdiction. And finally, a motion to dismiss based on the doctrine of corpus delicti. Starting with the first point, the state has not presented any substantial evidence that Alissa is deceased and that Mike caused her death. The state's case rests entirely on speculation, character evidence, and rumors. This entire trial has been about Alissa and Mike's relationship, what kind of teenager Alissa was, whether they had an acrimonious relationship, whether Mike was a bad parent, or if he was paranoid. There has not been a shred of physical evidence in this case. No body, no crime scene, no blood spatter, no body parts found in the house, no murder weapon, no evidence in the houses or in the car to suggest that a murder took place. The fact that Mike's home was searched 7 years after Alissa's disappearance has everything to do with the Phoenix Police Department's failure to investigate this case. Mike was the one who pushed the police to take a more aggressive approach to find his daughter. He did his own investigation. He worked to draw attention to his daughter's disappearance. Now, the state points to Mike's relationship with the Phoenix Police Department as evidence of his guilt. He was either too involved or not involved enough in the police investigation. The state cannot use Mike's involvement with this investigation, or lack of involvement, as a sword and a shield. Now, although defense does not have to prove innocence, there is sufficient evidence to show that Alissa ran away. There was testimony from Alissa's family and friends who described her as a free spirit, someone who was impulsive, stubborn. Mike was strict and controlling at times, and Alissa did not do well with rules. Alissa had a bank account that was set up by her father, and there's no record of at least 5 months of her paychecks being deposited into that account. Alissa had a fight with her boyfriend and cheated on him right before she went missing. There was, of course, the call with Aunt Lynette that happened at least 6 weeks before Alissa's disappearance, where she said, "You can always come see me." Finally, we have the runaway note, and then the call from California a week later. The state has not presented any evidence that Mike had to represent the mens rea that's required for a conviction of second-degree murder. The state must prove either 1, that Mike intentionally caused the death of another person, 2, that he caused the death of another person by conduct which he knew would cause death or serious physical injury, or 3, under circumstances manifesting extreme indifference to human life, he recklessly engaged in conduct that created a grave risk of death and thereby caused the death of another person. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. We sat through 5 days of trial, and the state has not presented any evidence to prove that Mike acted intentionally or recklessly to cause the death in this case. There's no confession, no evidence of a plan, and no evidence of how a death occurred. On to defense's second request for dismissal and for failure to establish jurisdiction, there's no evidence to show that Mike committed second-degree murder in Maricopa County. No crime scene was physically located in Maricopa County. No witnesses to a crime in Maricopa County. No murder weapon located in Maricopa County. and no body found in Maricopa County. Finally, defense asked this court to enter a judgment of acquittal based off of the doctrine of corpus delicti. Corpus delicti is intended to safeguard against erroneous convictions. Arizona courts have recognized that jurors often take confessions or inculpatory statements at face value. And to be clear, Mike has not confessed. However, the state has elicited several statements during trial which it believes demonstrate consciousness of guilt. For example, the union killed Alissa, or come to my deathbed. The corpus delicti doctrine requires that the court find, separate and apart from Mr. Turney's statements, that the state has presented direct or circumstantial evidence that establishes a reasonable inference that Alissa is dead and that her death resulted from Mr. Turney's conduct rather than by death, suicide, accident, or somebody else's criminal conduct. For the reasons mentioned previously, the state has failed to do that. And if the state has failed to submit adequate proof of the corpus delicti before it rests, the court should direct an acquittal. Judge, for these reasons, we are asking the court to enter a judgment of acquittal at this time. Thank you.
Thank you, Ms. Hicks. State's response.
Your Honor, we would submit that the law does not envision a person who murders someone simply because they have disposed of the body where it cannot be found, simply because they have managed to commit this crime without leaving physical evidence when there is circumstantial evidence.
What circumstantial evidence?
To escape being held accountable. That is not what the law envisions. Let me, first of all, and I'm really not sure which order to take this in. I'll start with the Rule 20.
Stop jerking off the
and talk about
microphone.
the corpus delicti issue afterwards. So I'm going to read some quotes from some cases that you've read. The relevant question in a Rule 20 motion for judgment of acquittal. And I don't have these memorized, so I'm going to look at my screen and read. After viewing the evidence in a light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt.
I consider
State
myself
versus Potter,
rational.
231 Arizona 391, State versus West 226 Arizona 559. You could, all of us here who work in this area, I could list probably another 50 or 60 cases like that. Furthermore, if reasonable minds can differ on the inferences to be drawn from the evidence, a trial court has no discretion to enter a judgment of acquittal and must submit the case to the jury. So in this phase of my response, I'm going to talk about statements the defendant has made. Because absent the corpus rule, and I don't agree with the position on it, those statements can be utilized.
You have rested. You can't use them here, now.
So we have a 17-year-old girl who had family and friends. She had a cell phone. She had her mother's jewelry, which was important to her. She had makeup, which was apparently important to her, according to the testimony. She had a home. She was unhappy with the defendant. She had family and friends that she could have gone to live with. She had family and friends that, based on history, it is.
You never looked at the aunt's house.
Circumstantially, you can infer she would have contacted those people if she were alive. You could go to court. You could go to another building here and have her declared dead because she's been gone for 22 years. The last person to see her alive was the defendant.
That you
Picked
know
her
of.
up early from school, he claimed, because he needed to discuss her plans for the summer. Discuss her plans for the summer with a young lady who lived with him. He could have discussed those plans the night before, the next day, the day after, the day after that. There was absolutely no reason to pick her up from school early unless he had an intention.
What?
To get this young lady out of his life.
What?
which was apparent from that phone conversation he had with his natural son, Michael Seth Turney. She was a fucking bitch, he said. She was a pain in his side. He could not take it any longer. My words. Inference could be drawn from the words that he spoke. A 17-year-old girl does not leave home without her cell phone. She does not leave home with no intention of returning without taking the things that were important to her. She does not leave a note saying she's running away and climb out a window, not to be seen on a video from that day. A video the defendant claimed that he had watched and there was nothing on it, and then he destroyed it. He didn't keep it for someone else to look at. He wanted people to believe that she would write a note to leave with whatever it was she took with her and climb out a window and not go through the door that she always used. So to be seen on
Because she
video.
knew she would be
So
recorded.
a video surveillance that, if you
The-
remember the testimony from Sarah, he turned it on when he left the house, when he wasn't there. But again, he said, I watched it. She wasn't on it. That's just not possible. He got rid of it. He claimed there was a phone call from California. Wasn't recorded. When he had calls recorded for decades, he got rid of it. If there was one, we know there was a call, but no recording of that call.
Yeah. Yeah.
When you combine the nature of their relationship, how he denigrated her over the years, how he basically said to his older son, I can't stand any more of this fucking bitch. He takes her from school when there was no reason. She had a job, Your Honor, where she would be going to work when school was over at Jack in the Box. We don't have to prove how he killed her. We don't have to prove whether he strangled her, whether he beat her, whether he struck her. All we have to prove is that he killed her. And there is circumstantial evidence that he did. All of this, he was a former deputy sheriff. So what they want you to believe, Your Honor, is that and the jury believe, is that all these efforts he made over the years was because of a genuine desire to find her. No, it was to create this image of a father who wants to find the daughter that he's murdered. He knows they're not going to find whatever he did with her. He suspects they're not going to find her body. They're not going to hear from her because he knows that she's dead. Now let me talk about
Damned if you do, damned if you don't.
They filed their motion last night. I hadn't had a chance to do a written response. So if you'll give me a little latitude here. I'm going to cite some from a case, State versus Derek Gerlaw, 134 Arizona 164. Even without, it's on the issue of the corpus delicti rule. Even without this evidence, however, we believe the state had established the corpus delicti. The purpose, I'm skipping here around, so if you want to go read the case and make sure this is what it says, feel free to do so. Defense can as well. What I'm getting to here is the history of this rule and why. What's the purpose of it? And remember, Ms. Hicks stood up here and said to you, the defendant has never confessed. The defendant has never admitted his guilt. The purpose of the corpus delicti rule is to prevent erroneous convictions based solely on untrue confessions. She just stood up here and said her client didn't confess. So there's the rule doesn't need to protect an untrue confession.
They have alluded to confession via innuendo.
In that Gerlaw decision, they cited Perkins and Boyce on criminal law, a Harvard Law Review article, which I would never cite, but they did.
Oh,
rationale.
fuck you.
This language is particularly critical here in this analysis, Your Honor, because we have to understand the purpose of this rule. The rationale for the corpus delicti rule was the realization that confessions may be untrustworthy because of involuntariness due to improper police conduct or unreliability due to the mental instability of the accused. That's not even their position here. Their position is there hasn't been any police misconduct.
No, he's talking about the phone call. When he's talking about got rid of it, it is the videotape from the day of the disappearance. And they claim it wasn't recorded. Yeah, but you have the burden of proof. But since the police never investigated until 2008. Yeah, I know, but those aren't admitted. Okay, Vices. Oh, hey, Vice. Hi, Vices. Hey, oh, hey. Okay. Wow. Okay. The numbers are ticking up. Yeah. Yeah. I think yeah. Vices rate. Yay. Okay. We are in the middle of the defense has asked the court to do a directed verdict, and they did a damn good job of it. It's a legal Vices raid. Oh, I will send Jeff a link so he can be with us for a couple of minutes, maybe. Where are you? There are you. The sound, yeah, the sound is crap. It's law and C words fault. It's crackling up. I sent Jeff a link. The defense have moved forward with a directed verdict and other things to say that they have, throughout the trial, they have no evidence. No physical, no body, no nothing, no crime scene, no murder weapon, no nothing. All they have is rumors, innuendos, and allegations. Hello, everybody. It's me. It's a legal Vices raid. Yeah, and so they did a damn good argument. I urge you to go back 15-20 minutes and listen to their argument. So the rest of us can continue, because now this the prosecutor. Thank you. Time to Jeff. Good night, everybody. Say good night, Jeff. Night, Jeff. Yeah, no banning people in your sleep, Jeff. Now, this prosecutor, of course, don't want to hear about it. No directed verdict. And now he's referring to different law review from Harvard, and he is speaking about other things. Now, we all have to understand that directed verdicts are extremely rare. But in this case, I believe that it should be granted. I'm playing this in a higher speed because, yeah, this guy is slow. But as again, the crackling in the sound from the law and seaward stream is on them, not me. Just so you know.
That led to an untrue confession. In the Gerlach case, Your Honor, that defendant confessed to killing the victim in that case, but it wasn't recorded. It was 1980. They didn't record his confession. So you had a detective testifying, this is what he told. So the issue was there evidence independent of that confession to corroborate it? Well, okay, that's the purpose of the rule. But it doesn't serve a purpose in this case, and it doesn't apply in our factual situation. Therefore, any confession, admission, which they claim doesn't exist, any statement that this defendant made can be utilized to prove this case. Thank you.
Thank you, Mr. Amordino. Ms. Hicks, I will give you the last word.
Just a moment.
Remember to like and subscribe if you haven't already. Thank you.
Judge, turning first to the corpus issue, the case law says that that the term confession can be used interchangeably from statements that are made throughout the case. So we would be requesting not just, clearly there's been no confession here, but any statements that are possibly inculpatory to be suppressed. And that's based off of State v. Jones, 198 Eras 18. Judge, Mr. Imbordino stated that circumstantial evidence, that the state has presented enough circumstantial evidence that Mr. Turney has committed murder. But the only circumstantial evidence that they've presented during this trial is evidence of his character, not of a crime that's been committed. He said, you know, he was the last person to see Alissa, but we don't know that. We don't know who the last person was to see Alissa. And that's, obviously it's horrible that there's a young woman who is missing, but it's not Mr. Turney who's responsible.
Don't know that yet.
Finally, Mr. Imbordino mentioned that with Rule 20, the evidence must be viewed in a light most favorable to the prosecution. And while that is true, the evidence must be more than just a scintilla of evidence, which is all that the state has presented here. Thank you.
Thank you. I have considered the issues raised by the defense and the state's responses to those. Taking the corpus issue first, the court has to consider the evidence that is before this jury and exclude from that consideration the defendant's statements. While there are cases that do suggest that the corpus rule is limited to confessions, Ms. Hicks is right. There are other cases that use the term statements. So when looking at this case without the defendant's statements, the court has to make two findings. Is there a reasonable inference that Alissa is dead? Or could the jury make a reasonable inference that Alissa is dead? And the second question is does the court or the finder of fact have the ability to make a reasonable inference that Alissa's death resulted from the defendant's conduct? The court has considered the evidence presented without the defendant's statements. The court finds that there is a reasonable inference that Alissa is dead. I find that this court could make that reasonable inference and that the jury could make that reasonable inference. The second question is there a reasonable inference that Alissa's death resulted from the defendant's conduct? There is really no testimony about the defendant's conduct in relation to Alissa's death. The defendant raised Alissa, and the court is not here to decide if his parenting style was appropriate or inappropriate.
Will it happen?
The court's not even deciding if the defendant killed Alissa or not. The court is deciding whether or not a reasonable inference from the evidence that has been put before the jury, excluding his statements, shows
No spoilers.
that a reasonable inference can be made that the defendant caused or the defendant engaged in conduct that resulted in Alissa's death. The court is unable to make that finding. It is ordered granting the defendant's motion to dismiss based on the corpus delicti rule.
He's off.
The second question is whether or not substantial evidence exists to warrant a conviction. In some ways, I could just skip this and say the issue is moot because of my ruling on the corpus issue, but for purposes of the record, I'll make the finding anyways. There is evidence in the case. I am not here to suggest that the state has put forth no evidence. There is evidence. The court has to determine whether or not there is substantial evidence. And the evidence doesn't have to be direct evidence. It can be circumstantial evidence. There is
Jesus Christ.
circumstantial evidence in the case. The question then becomes, is it substantial that would warrant a conviction for second-degree murder? The court has considered the evidence and finds that substantial evidence does not exist to warrant a conviction. It's ordered granting.
Holy
a
shit.
motion for a Rule 20 judgment.
Holy shit. Holy shit.
I will order the defendant released as to these charges only. Mr. Turney, you're going to be signing for a copy of your release. I'll bring the jury back in and just let them know that their jury service is over. Before we do that, anything for the record from the state? Anything for the record from the defense? All right, Angela, you can bring the jury.
Holy fuck. Holy fuck. Damn. And Jeff missed it. Ha! Oh, sorry. He's free to go. Jesus. Okay, I've said it from more or less after the first witness. I don't think they have any. Even after the. Oh, you didn't miss it. You didn't miss it. Holy crap. Holy crap. Yeah. A directed verdict. Now, I said to you, I believe this should be granted. But I didn't think it would. I really didn't think it would. Jeff, are you sure you don't want to come on and talk about it a bit? Yeah, Judge, I believe Judge did the right thing.
Please be seated.
Holy crap.
In State versus Turney, let the record show the presence of counsel and the defendant and the jury. Ladies and gentlemen, during the break, I had to make some legal rulings, and as a result of my rulings, the trial is now over. You are now discharged as jurors, and the admonition is now lifted. You can talk to anybody that you want to talk to about the case, but you don't have to talk to anybody if you don't want to. I will come back to the jury room in a moment to thank you in person for your service.
It's
Sometimes
dismissed.
the attorneys like to come back and talk to the jurors after a trial. If you want to stay and talk to them, you're welcome to do so. But if you want to just gather your things and go, you're welcome to do that as well. On behalf of the court and the parties, thank you so much for giving us your time for this trial. It was important and meaningful, and the court and the parties and the community recognize that our criminal justice system cannot function without people who are willing.
And I was here for it.
Which is give of your time and attention for purposes of sitting and listening to evidence in a case. So thank you so much for that. Please take everything with you into the jury room. Again, I'll come back in just a moment and thank you in person. Jury is now excused.
He stood up really fast. If he walks out, I'm going, no, sit down, be rolled out, not in front of cameras. We were all here when it happened. Thank you, Jeff, for allowing your audience here to witness this with me. Oh.
Let the record show the presence of counsel and the defendant. Jury's not present. Anything for the record from the state? Does the state want to talk to the jury? Anything for the record from the defense?
No, Your Honor.
Does the defense want to talk to the jury?
I do if they want to. I don't.
Okay.
Seek out, but if they want to, I will.
If you just stay here, I'll have Angela come and get you if and when the jury is ready, or she'll let you know that they're not interested. Angela is going to come back in and have defendant sign for a copy of his release.
I don't think
we
so.
are here.
I think he's free to go with a directed verdict. They can't retry him.
No, I know that Court TV gave me some documents. I will give them to you.
Oh. Yeah. Oh, that would be interesting. That would be really interesting. I assume so. I would assume so. That a directed verdict is the exact same thing as a not guilty verdict. The defendant is free to go. The defense motion for a directed verdict was granted. Vice is raided at the right time. Buzzkill, the state can appeal. But I highly doubt they will with a directed verdict, which is extremely rare. Okay, Erica says state cannot appeal. I don't know. We will probably hear about it the coming days. If news about when news starts showing up, and the prosecution might give a press release about we will appeal, or we will yeah, he still has to go to jail to be freed officially. And Mr. Turney has been in jail for 2 years. He was arrested in 2021. And he couldn't afford bail. He was stone broke after, because he spent 7 years in jail, in prison, between 2010 and 2017. And he has been on disability since. He couldn't afford to be bailed out, especially not on a second-degree murder charge. It was too expensive. State of Arizona wasting money again. Yeah. And I said this early on, that I have the tractor in my face. I said this early on, moving the tractor, that the only reason they prosecuted was because of public outcry. The podcast, the attention it got, and without it, this trial would never have happened. So it's politics. This will put a dent in the prosecution's career, but he is 75 years old, so yeah. This is, yeah. Yes, Stumpy did good. Yes, the state can definitely can appeal, because the judge is not the fact finder. If it was a bench trial, the appeal options would be less likely. Okay, so they do have the option of, I'm not muted. Am I muted? I shouldn't be muted. Stop screen. Am I muted? Yeah, this is the verdict that should have been in the Zachariah Anderson case. But now instead we have to wait for appeal and everything. Stumpy just gave the prosecutor a 1-2 punch. Okay, I'm not muted. Okay, good. Yeah. Hello, John. You missed everything. This trial is over. I was expecting the motion, the directed verdict motion to be not granted, because it's so extremely rare. And then maybe, oh, is that? Hold on. The poll is still up. Will Michael Turney testify? And the answer is no, because the trial is over. Oh, A directed verdict. Yeah. But as I started to say, without the podcast, without the sister and everything. And I do know that David, together with Josie, I believe, will do a comparison of Sarah's testimony in the trial with what she testified to in court. Apparently, it is not very, very different. Now, it could be because she couldn't talk about some things, or she was under oath. Because if she says stuff that are so completely different from everything else, yeah. So do we listen to the podcast? You know what? David has already announced it, that he and Josie will do a something. They will do a stream of sorts with that. So I will leave that to David since he's already announced it. Okay. Tomorrow it's Jodi Arias Day, and it's noon Eastern time, 6 p.m. my time. And I will later this week, I will have an update on the Andrew Tate case. So I wasn't prepared for this at all. And then I will have new things about Young Thug will be out there also later this week. And yeah. You know what? I see that Broken Baker is still on. And yeah, it's very nice to see a judge actually doing the right thing. What are you supposed to listen to? You are supposed to get over now to Broken Baker. He is doing something about the sentencing of Ronaldo and some other bits. So I will be sending you over there. And yeah, thank you all for showing up. I was so glad to be here with you. So glad that you chose. Oh, most of you were directed over here by Jeff. Thank you, Jeff. And yeah, I'm sending you to Broken Baker. Thank you.